Hi, good evening. Today is November 7th, 2025, and it is 8:06 p.m. U.S. Central Time. My name is Rinaldo J. Aguiar Marcano, and I'm recording this video from my home located at the 2302 Britton Ridge Drive, Katy, Texas 77494. And I'm going to give a little more information about the location. So this house is in a compound, in a neighborhood. It's really a compound, but let's call it a neighborhood. But it's called Lake Point Estates in Katy, Texas. It's on the southwest of Houston, Texas. And this particular house is in front, and all this is relevant to what I'm going to say in this demo. This house is in front of the house of a man by the name Joel Grade, who is the chief financial officer of Baxter International. And both of our houses are 300 feet away in that direction from the house of Robert Mueller, who is a former director of the FBI. So he directed the FBI for many years ago. And all this is relevant to this conversation. So today, this demo is, I hadn't done this before, but I counted how many of these demos I've recorded, and this is number 86. Depending on how you count it, right? Because sometimes I do addendums and things like that, but not counting the addendums, this would be demo 86. So, if this was a Netflix show, we would be on season 7, right? And this is going to be a very interesting one. So, oh boy, where to begin? So a lot of good news, right? I think I finally got Mr. Pickett to come out of the, let's call it the castle of quiet, right, where he was. So he finally spoke, right, and kind of committed to a position. But I'm going to give a little bit more technical details on the infrastructure that I have developed for this. But the pipeline, the legal vaccine, which is a data pipeline that I developed, it thinks that this is really Morgan Hybner falling on her sword, right, so to speak. So the pipeline thinks it's I would call it the scapegoat algorithm, right? And I don't like it's hard to explain this without giving too much data, right? How about this? Let me tell you what I did. Okay, I don't know if this was in. I don't know if this was a consequence of what I did, but a few weeks ago I planted a seed in the Docker, kind of to give them an exit, right? Because I saw something in the data pipeline, that in a metric that I have, that told me that they were, they had no exit, right? They were cornered. So it was a strategic move in a way, right? But again, I don't know if this series of events that I'm going to describe in this demo are a consequence of that or not, right? So because that's not so important, like how we got to this point is not really that important. I think it's more important the observations, right? But I'll tell you at the end what is it that I did, right? That could have contributed to this. But I'll start with the observations. I think that's way more important. So this is the sequence. I'm going to tell you the sequence of events that happened today, and how Mr. Pickett came out of the castle of quiet. And I say that because he hasn't said a meaningful word in any of the 2 cases that he has been in for the last 2 months, right? I'm talking about the appellate court case that got dismissed procedurally without looking at the merits, because the orders had supposedly been signed on the 10th due to a fraudulent document that Morgan Hybner filed on the 387th court. And this is described in a previous demo, right? And then he came, so he was on the appellate court case. But then after the fraud with the document of Morgan Hybner was discovered, Morgan Hybner tried to leave the case, and then he was brought in to the family case now, right? But he, in either of the two cases, he has ever mentioned anything meaningful, like he hasn't objected or replied to anything except today, right? I think today was the first meaningful. Like the other day, he contested, he objected to my motion to recuse, which he shouldn't have, right? Because the motion to recuse is against the judge, right? It's directed at the judge, not at him or his client. And I mentioned this in a different demo, but that response was very, it lacked substance, right? It didn't say anything. It looked like something copied from a template, right? And I think I mentioned this before. I think that was deliberate to like make it look like it was like a theater of incompetence, right? Like to make it look like he's not that sophisticated, like he couldn't be the mastermind of this, right? But anyhow, so today, so the sequence, I'm going to tell you the sequence of events, right? So the situation is, right, I filed the second verified motion to recuse on October 15th. And I did this on purpose, right? At the end of the business day. And I did it that way so they couldn't do exactly this thing that they did. Or to make, well, I mean, they did it, right? But to make it more difficult, more obvious that they did it, right? Because if I filed the document after hours, they could not possibly sign the orders, right? At 11 p.m. because the court is closed, right? So I filed the document at 8, I don't know, 8:59, something like that, right? No, 8:40. I'll give you the exact time, but it was in the evening, right? And we're waiting for the decision on the motion to recuse. That's the current status. Now in Texas, as some people will know, right? If you're familiar with the Texas legal system, there is a rule that says that when a motion to recuse a judge is filed, there is an automatic stay on the case, meaning the court loses all jurisdiction on the case immediately, right? Automatically. Nothing can be done, decided, or any action. No action can be taken by the court until that motion to recuse is decided on. And the reason for that is to protect the person that is filing the motion, right? Because otherwise the judge or the court could retaliate, right? And use that position of power that they have to retaliate against the person filing the motion, right? So the situation is that on October 15th at 8 p.m., when Morgan Hybner was served with that document, at that moment, an automatic stay was triggered, right? Like nothing else could be done. And we're still waiting for that answer to the motion, to second verified motion to recuse. Also, there was an order, temporary orders, verbally rendered by the judge on September 11th, Judge Oscar Telfer III. And he said on the record that the duration of the orders was for 60 days and that we would review on 60 days to see how the orders felt. That was the standard of review that he said, right? I mean, you cannot get more subjective than that, right? There was no clear path. Sorry. In that verbal order, it's clear that there is no clear path for me to restore my parental rights, right? Because it all will depend on 60 days on how it feels to the judge, right? Anyhow, I digress. So that was the status. Like, so when I filed that second motion to recuse on October 15th, the orders had not been signed, and we had a hearing scheduled for the 16th, for the next day, at 9 a.m. The court would hear arguments on that date about the draft that Morgan Hybner proposed that was heavily contested. She had proposed 3 different drafts at that point. Okay, the first one she sent it on October 2nd. And all this, I'm going to give you a lot of details about dates and things like that, but it's relevant, so we can debug what happened, right? So the first one was October 2nd. That was the draft she sent. And I immediately, in writing, filed a document objecting the fabrications because she changed everything, right? She invented things that the judge never said, especially the duration of the orders. The judge said clearly, and I have this in the unofficial transcripts that I have, and this should be in the recordings of those hearings, right? So I encourage authorities when they inevitably investigate this, and I say inevitably because if Robert Mueller is involved in this, I imagine the FBI is going to be involved, right? And I invite you, I ask you, I implore you to please look at the recordings, at the audio of the not the transcripts, because anything digital can be changed, right? I would encourage you to look at the audio recordings of the verbal rendition of September 11th. And you will see that the judge said clearly that the duration of the orders would be for 60 days, starting on that day, on September 11, 2025. And that's why we have a hearing on Monday, the 10th, because the 60 days will expire on the 10th. And that's when the judge was going to review how it felt to decide whether to extend it or not, right? But at that moment, October 15th, 2025, at 8 p.m. when I filed that second motion to recuse, the orders had not been signed. And that's why I had that petition for a writ of mandamus on the appellate court to compel the judge to sign the order so I could appeal them. Like the whole point of my petition to the appellate court was to ask the judge to sign the order, right? Because he hadn't signed it. Right? Now, when we had a hearing on the 10th, right? And that's where I objected on the record to the draft. I verbalized my objection on the record, and this was on a Zoom meeting. Okay, so this should be recorded in the Zoom servers. So I also invite the FBI to look at all the Zoom recordings. And I described this in writing, right? In my motion to recuse, the judge shut me down and he didn't let me speak, right? I objected. Then he said, well, he said on the record, right? He said, obviously, this draft is heavily contested. I want you back here in person on the 16th. So what he said is that on the 16th, I would have the opportunity to be heard about my objections to the draft, the fraudulent draft full of applications that Morgan Hybner had submitted for the third time, because she submitted one on the 2nd that I objected to. Then she submitted one on the 7th, October 7th, that I objected to in writing as well. And then she finally submitted one on the 9th, the day before the hearing of the 10th, right? So, and I objected to that as well in writing, right? So when we get to the hearing on the 10th, I tell the judge, I already filed my objections to this. This is a complete fabrication, what she's proposing, right? The judge says, let's meet on the 16th. On the 15th, because he shut me down and he didn't let me even speak, right? I asked clearly, I begged him, I literally begged him to allow me to be heard, and he shut me down. So I filed a second motion to recuse, right? And it has like 10 arguments, like that's not the only reason. There's like 10 big reasons, right? And they're all in that document that is filed with the court. And I filed a copy of the document with the federal court. So the federal court also has a copy of those objections, of the reasons for the recusal, basically. So I filed on October 15th that second verified motion to recuse, which triggered the automatic stay, right? And nothing else can be decided on the case. Now, this is where it gets interesting, right? So let's just start by this, right? Let me share my screen with you. I think it's a good point to start debugging it, right? So the sequence of today starts because, and I waited till today precisely to force this to come to head, right? So the real situation is that on Monday, the 10th, the verbal orders are going to expire. And we are all waiting for the decision on the motion to recuse, right? So the situation is that on Monday, November 10th, November 10th, really, 2025, the verbal orders are going to cease to exist. And there's no written orders because the judge was supposed to hear arguments on the 16th, but I filed the motion to recuse on the 15th. And the court lost all jurisdiction immediately. It's automatic stay, right? So I sent a notice to the administrative judge that is handling the second motion to recuse, that is reviewing it, right? Stating the fact that the verbal orders are going to expire on Monday and that the child is going to be unprotected because then there's no orders governing this chaos that is being created by this court, right? And by Pickett and Morgan Hybner with the fraudulent documents and the fraudulent filings, right? So the child is going to be unprotected, right? And crucially and interestingly, Morgan Hybner hasn't come out to create urgency on this. And remember, she is a person that on April went behind my back and secured an ex parte hearing, her alone, with a judge, and got a temporary restraining order against me that then she hid from the docket. It's not in the docket. I'm talking about index number 7. It disappeared, right? And somehow she convinced the judge that I was a person so crazy that this was required, right, to protect the child. But now the child is going to be left without any orders governing this, and she has done nothing to create urgency on the administrative judge that is reviewing this, right? So it's a glaring contradiction on her own stance and position towards the urgency to protect the child, right? So when she needed to secret the child, there was urgency, right? But now that she's basically in hiding, I guess, then now there's no urgency to protect the child, right? So I filed this document in the morning, right, saying the orders are going to expire, they are not signed orders, and the child is going to be left unprotected, like to communicate to the administrative judge that there is urgency in deciding this motion to recuse because the child is unprotected, right? Immediately, within 1 hour or 2 hours, something like that, Piquet replied, right, with an answer that is not a pro forma, templated answer, right? Like he actually wrote something relevant to what I was saying, right? So let me show you what he wrote, right? Let's just start by that. Okay. So he filed this today. You can see here at the top, right? Let me make sure that you can see. Yes. So he filed this on November 7th at 2:51 p.m., right? And he's saying basically, oh no, sorry, I filed this. Let me see if it's here. Oh, I don't have it here, but I'll tell you. I'll put it in this folder, and I'm going to tell you what this folder is in a minute. But I'll put it in this folder. But he basically said 2 things, right? One, that I was wrong, that the orders had been signed on October 15th, and the legal vaccine already saw this weeks ago, right? But I was waiting for him to commit to it because if I say it, then they will say, "Oh, this was an error." Right? But now he committed, right? So this is exactly what I wanted. So he says, right, clearly in writing today in a filed document with the court that the orders were signed on the 15th. And importantly, that because I said the orders are going to expire. And then he said, no, the orders are not going to expire because the orders that were signed are in effect until the divorce decree is final. So he's committing to the position that they are basically changing the temporary nature of the orders. The judge verbally said this, and this is in the audios. Like if I plea to the FBI, please get a copy of the hearing of September 11th, and you will hear the judge said that the orders are in effect for 60 days. So right there in this filing of today, Pickett is committed to the position that they're changing unilaterally what the judge said, right? And he's making the orders that were supposed to be temporary for 60 days indefinite, right? He's stripping me of my parental rights for no reason, really, because the judge said on the record that he had no reasons to order a psychiatric evaluation. So Pickett is unilaterally stripping me, or pretending to, from my parental rights indefinitely, right? So he's committed to that position. He committed today to that, right? And he said that the orders were signed on the 15th, right? Which the pipeline already found this inconsistency weeks ago, but I was waiting until today, right? So they have no wrong way to change anything, right? And he committed to it today. So, and this is a tremendous, huge anomaly. There's multiple anomalies here, so many that, and maybe this is a good point to tell you. So there's a metric that I developed that I call the kingpin metric, okay, in the legal vaccine. And it's a metric that measures the level of sophistication of the fraud, right? So on each instance of suspected fraud, so the pipeline flags, suspected procedural fraud, right? Because that's the TTP, or that's the type of TTP that they apply, right? So the pipeline finds the candidates and assigns a score that tries to mirror. This metric it's an inference, right? It's an inference based on a series of factors, but it tries to estimate or assign a score to the level of sophistication of the fraud, right? Of each instance of suspected procedural fraud, to put it in a way, right? So the idea is to be able to rank them, right? And the finding, or the interesting observation, is that the kingpin score of this particular procedural fraud of October 15 is very low, meaning that this is a fraud so obvious that a child would probably see it, right? It's just too obvious. It's too easy to see, right? So, and this is an interpretation that is mine, right? I think this is maybe by design. Like this is maybe just a way to create a scapegoat, right? To create the narrative later on, right? If it comes to that criminal charges surface, right? To create the narrative that this was Morgan Hybner, who was an aggressive attorney that cut corners and committed fraud because she wanted to win all her cases, right? Like something like that. But this is by no means a state-sponsored operation, sponsored by Venezuela and China, right? It's not. And it has nothing to do with Robert Mueller, of course, right? So the narrative is that this is just Morgan Hybner acting in the worst case, criminally, but they may try to play it as, well, it was a procedural error, right? Like this was just a clerical mistake. So if they can, sell that they will. But if it has to involve some sort of criminal charges, then it will be only Morgan Hybner, who is already in the hole, right? But it's a way to build an alternative narrative that doesn't involve Mueller, right? And Joel Gray, and the state actors, right? I'm talking about, as I state actors, I'm talking about foreign and domestic, right? So that's because it's just too easy to see, right? And you'll see what I mean. It's just too easy. Okay, so now let me show you the docket, right? Okay, so I'm gonna do this here with you to show you, right? Okay, so the anomaly starts here, right? So October 15th, right? So okay, so we already talked about this, right? On the 14th, the First Court of Appeals dismisses my petition for a writ of mandamus based on that the judge already signed the orders, right? So, and this is very important. So this letter on the 14th says that the orders were already signed, right? So supposedly before the 14th, because how can? And this is the fraud that Morgan Hybner committed on the 10th, where she filed a document saying notice of entry, temporary orders, this one, index 81, right? You can see it here. Notice of entry, temporary orders, but I showed this document in a previous demo, and it's not a notice of entry. It's really a notice of a scheduling of a hearing to talk about the temporary orders, right? So she mistitled the document to trick the appellate court. And the appellate court fell for that trick, right? And on the 14th, they said the orders are already signed, so, this is a moot point. So they dismissed procedurally my petition without examining the merits. So on the 15th, Morgan Hybner, because remember, we had that hearing scheduled for the 16th that Judge Telfair scheduled from the bench on October 10th, saying that I was going to be heard on the 16th about my objections to the draft, right? So on the 15th, right, Morgan Hybner files, Tina Simon, on behalf of Morgan Hybner, she filed the petitioner's exhibit list for the entry of the temporary order, supposedly, right? That was going to happen on the 16th, right? On that hearing where she was hoping to get her order signed. And she served me with a document, and you can see that document here, right? That was the only document they served me on the 15th, nothing else. And I can show you that I did that search on my email, right? And the only documents that were served on the 15th was that document from her and the two things that I filed. You can see there's three things on the 15th, 1, 2, and 3. There's one from her, which is the exhibit list of 11 a.m., and then there is a document I filed at 4 p.m., and then the motion to recuse at 8:19 p.m., I think, something like that, after hours, right? The court was already closed. So those are the only three filings, the only three notifications of service that were received in my email on the 15th. And there was only one from them, and it was the exhibit list, because we were going to have that hearing on the 16th, right? But now look at this, look at the fraud. The fraud is right here, right? So on the 15th, this entry appeared, right? And it says, Judge docket entry, court signs temporary orders, and it is initial OT, which I imagine is Oscar Telfair, right? So supposedly, the judge signed the orders on the 15th, right? That's what they're saying in the docket, right? Now, I have to tell you, Morgan Hybner never served me those orders. In fact, I'm showing you a screenshot that shows in my email that nothing, there's no possibility of anything being served, because I did this search for notification of service, which is the title that comes in the emails for service from this e-filing system. And there's only 3 services on the 15th. One is Morgan Hybner's and my 2 documents, right? And you can see that here in the docket, right? So on the 15th, this is the document that she served me, index 87, which is exhibit list for the hearing of the 16th, right? And here are my 2 documents, right? A notice I filed, notifying them that I filed an emergency motion in the federal court, and my second verified motion to recuse, right? So those are the 3 things that were served. So they didn't serve me with anything on the 15th, right? And if they had served me, they should have the certificate of service, right? That this system generates. They didn't serve me with anything, right? So that on itself, it means that the order is invalid, right? If there's an order, it's invalid because they didn't serve me with it. But this is the same TTP that she applied on April, what was it? April 10th, I think, right? When she went and got that mysterious index number 7 signed, but she never filed it. And she never served it to me, right? She served me something else that was misleading, right? That made me think that it was a standard orders, but she really got a, I think, a temporary restraining order against me without me even knowing or being called to a hearing, and she never served me with it, right? So she had that document secreted somewhere, right? But it's the same TTP, right? Getting the order, getting the judge to sign something and not serve it to the other party, right? So they have an order that I don't know exists, right? And now Pickett is saying that is this document that he sent today, right? Because he attached the supposedly signed document, the supposedly served document. He attached it to the thing. Oh, I think where I can show you the thing. In my objection, right? In my objection, right? So this is the objection that I filed, right? At 2:51 p.m. But in my objection, I attach his document, and you can see what he's saying, right? So this is what he. So he says, fact one: the orders the orders are in written form and signed by the court on October 15, 2025. So he's committing to that in writing, right? And he attached the supposed orders. And fact two: the temporary orders are not set to expire on November 10. See page 35, these temporary orders shall continue in force until the signing of the final decree of divorce. So he's there saying in writing that they changed what the judge said verbally, because that's not what the judge said, right? And that's in writing in my objections. This also means, if this is true, right, of course, now we have to debug, how they created this document, because there's two possibilities, right? The document could be real, the judge really signed it, but that would mean that he tricked me, right? The judge set a hearing for the 16th and then signed on the 15th without really giving me the opportunity to be heard that he promised I would have, right? This would be a tremendous violation of the process, because he's signing something that I objected, and it's not what he said verbally, right? And he promised that I would have a hearing on the 16th, right? The second option is that they forged the document, right? I'm talking about Pickett and Morgan Hybner. But this is why the pipeline thinks it's Morgan Hybner falling in her sword, because Pickett could allege that he's just coming into the case and he got this from Morgan Hybner, right? He didn't forge the document. Morgan Hybner, if anybody forged it, it would be Morgan Hybner, right? Because this was before he even came into the case, right? So that would wash his hands in a way. But this gets more and more interesting, in many different ways. And this is why I say that it's just trivial to see the fraud, right? It's too easy. It's really too easy, right? And it feels like it's designed to build a narrative that this is just a rogue lawyer operating, illegally in the worst case, right? But this is not a state-sponsored operation, right? So he attached it, right? So the first anomaly is that in these supposed orders that he's saying that are in place, the timestamp of the clerk is October 2nd, right? So that's an impossible timestamp, because if you look at this signature, suppose, like I don't know if the signature is real, right? They might have forged the document, I don't know, right? This is a question that the FBI needs to look at. I guess, right, that they should investigate how was this document produced, right, in reality. But if you look at the signature block, right, so it says that it was signed on 10/15. On 10/15, 2025. And my former partner signed this, right? And the presiding judge, this signature is illegible. I don't know what it says, right? But I don't see Telfair anywhere in there. But, it could be an illegible signature. I don't know. But crucially, this doesn't have the time, right? And in all the proposed orders that Morgan Hybner has submitted before in the last 6 months, in all of the proposed orders, there's always, in the signature block, it says sign on, and it says the time, because the time in these orders is important precisely because of this reason, right? Remember, I filed a second verified motion to recuse on this very same day, right? So when this order was signed, it's an important material fact. What time of the day, right? Was it before I filed my motion to recuse, or was it after? Was this signed at the 11th hour, right? If it was signed, if this is real, it was signed at the 11th hour, right? And I'm going to tell you why. But the first anomaly is that the timestamp of the clerk precedes the date of signature of the judge by 2 weeks, right? So this is the first anomaly. If she really got this signed and filed it with the clerk, this should have a timestamp on the 15th showing the time at which it was filed with the clerk, or later, right? Say that she filed it manually, right? But it should say the 15th or the 16th, right? But this document on the header, on the first page, is timestamped by the clerk on the 2nd, right? And remember, Morgan Hybner and Tina Simon filed on the 15th their exhibit list for the hearing of on the 16th, right? For the hearing that was scheduled for the 16th, and you can see that here. This is timestamp of the 15 at 11:07 a.m., right? So why would she file an exhibit list if the orders are already signed? It makes no sense. Like, why would you file an exhibit list if you already have your order signed? So she's acknowledging that there will be a hearing on the 16th to talk about this and if you look at the documents that she included, right? Number 2, she is including our email correspondence about the drafts, right? These emails that she's referring to are about the drafts. And number 1 is the comparison results of temporary orders. This makes it clear that the substance that we were going to talk about the next day was the difference, so the fabrications that she inserted in the orders, right? And she is including the October 3rd and October 7th email correspondence, which were the days in which she filed those drafts, fraudulent drafts, right? Proposed orders that had fabrications that I objected to. One of which was the one she filed on October 2nd, which is the one that Pickett is now saying that is the actual order, right? So let me show you. Right. So you see how this says October 2nd. This is when she really filed this draft. I mean, this is a real draft that she filed, but I objected to this draft on the 3rd, right? And that's the email exchange that she is referring. I objected in the email, via email, and I also filed an objection with the court on October 3rd. And you can see that in the docket, right? Like if you go to October 3rd, you will see respondents, index 71 is my objections to the petitioner's amended proposed orders, because she had filed another draft on the 27th, I think, of September. And then this was another change that she made. Like, she could make changes to this thing every time she wanted. Like, if it's supposedly an order that was verbally rendered, she cannot change the document at will. Like, it's supposed to say what they just said. Like, this is not open to interpretation of Morgan Hybner. But anyhow, the point I want to convey, right, is that this document that Piquet is saying that it's actually the order signed is a draft that she filed on the 2nd that I objected to. And then she subsequently filed another draft on the 7th, October 7th. Where is it? Here it is, October 9th, right? So on October 9th, she filed the first amended temporary order. Right? She amended it again. And again, I'm saying again because she had already filed 2 versions of the temporary orders, right? Of the drafts, of the proposed orders that were full with fabrications, including the changing of the term of the orders from 60 days to indefinite, right? So on October 9th, she filed another version. Now, this is interesting. This is very interesting because the version that was to be considered by the judge on the 10th, which is that hearing in which I objected verbally, the judge shut me down and told us to come back in person on the 16th, right? So the order that was in front of the court was, the proposed order from Morgan Hybner was the one that she filed on the 9th, right? But interestingly, the one that they picked, the one that Pickett, right, picked to attach as supposedly the signed order is the one from the 2nd. So one of the earlier drafts that had the more aggressive fabrications, right? So they picked the one that was better for them. Among all the multiple fraudulent drafts, they picked the one that was better for them, which happens to be the one that happened earlier in the process, right, on October 2nd. So they took that document that was a draft. It was a proposed order. It wasn't really a signed order. And so somehow they got the signature of a judge in there, right? I don't know if the signature is real or I think that's something that authorities, federal authorities, right, should investigate. How they got that signature, right? But the important thing is that this was never served to me on the 15th, right? And you can see that in that screenshot that I showed you. That shows that there were only 3 documents served on the 15th from both parties, right? In line 1, 3, and 4. One of those was the exhibit list of 11 a.m. of Morgan Hybner / Tina Simon, and the other 2 were my 2 filings of October 15. One being the notice, giving them notice that I had filed a motion for a TRO in federal court, and the second one being the second motion to recuse. No other services, right? So they didn't serve me with this document. The timestamp on the first page predates the signature by 2 weeks, and it's a version that was objected in writing the very same day. And they picked that version, right? Out of the 4 versions that they have of different versions of the drafts that they change in multiple ways, they picked the one that was better for them, right? The one of the second. And also, remember, Tina Simon and Morgan Hybner had filed an exhibit list on the 15th where they, it's obvious by the things that they pick as exhibits that they were going to make, or they were going to try to make the argument that these differences in the drafts were not fundamental changes to what the judge said verbally, right? Which is not true, of course. Starting by the duration, the judge said clearly 60 days starting from today, on September 11th, and they're changing that until the divorce is final, right? So it could be 2 years from now. So the question is, right, the logic tells you, if they were preparing to have this hearing for so they were preparing to have this hearing on the 16th, and at the same time, they had this signature on the same day of the judge, signing the orders that we were supposed to talk about the substance of those drafts and how they were fraudulent or not on the next day, right? So that tells you that it's fraud, right? Like they got that signature somehow in that page, but it's not, we never had the hearing on the 16th, right? So that it's a profound violation of the process, because if the judge did sign that, right? Let's imagine for a second the scenario in which the judge did sign that order. Then it means that the judge never really gave me the opportunity to be heard, because on the 10th, when I verbally objected in Zoom, he shut me down and he said, let's talk about this in person on the 16th. And then he signed the order secretly on the 15th, before that hearing really happened, right? So that would mean that the judge deceived me, basically, right? He promised me a hearing to hear me, and then he decided to sign the order and that, for all practical terms, basically eliminated any possibility for me to object, right? And I had the right to object to that draft, because the draft is not what the judge said on the 11th. So if the judge signed that, that would put the judge in this situation, right? I mean, and if the judge didn't sign, then it would mean that Morgan Hybner forged the document, right? Now, the pipeline, and I don't know much about this area because I haven't been, but the pipeline thinks that this could be considered wire fraud, because they're making, Piquet and Morgan Hybner, a series of financial demands, including payments of rent and things like that, based on nothing. Like, the judge never rendered those things verbally, right? There was no financial measures taken or orders given on September 11th. And they're fabricating the draft and this order that doesn't really exist, because they didn't serve me with it. And crucially, it is not, there's an automatic stay on the case, right? The judge cannot decide anything, right? So the suspicion, right, is that this fabrication was made as a desperate move to try to get something signed when the court had already lost jurisdiction, because the court lost jurisdiction the moment I filed that motion to recuse, right? But this is not just a theory. There is hard evidence that shows that the court had already lost jurisdiction. Let me show you this. So if you look at the docket, right? And the docket, the entries are out of order for some reason, right? I don't know if this was intentional, if there was collaboration to make this more confusing. But one thing that you have to look at the index, because the indices, and I'm telling you this as a software engineer that has been interacting with this system for 6 months. I already understand, right? I mean, I don't want to say that I know exactly how it works internally, but I have a pretty good idea of the logic of this system, right? Because I've been using it for 6, 7 months, and I know how the index get assigned, right? So the first anomaly you will see is that before the judge says that he signed on the 15th, the index entry was 87, right? And then the index entry for those supposed temporary orders, right, that I haven't seen because they never served me with them. Oh, before we go here, let me show you this other important piece of information. In the certificate of service of this, impossible document that Pickett is saying that is the order, right? If you look at the end, at the certificate of service, you will see that the certificate of service that he attached are from weeks before. So this one is from October 2nd, right? This is not from October 15th, right? So this is a certificate of service of the proposed order, and you can see it here, right? So this is what he's really giving us is what Morgan Hybner proposed on the 2nd of October. This is not the order that was signed, right? And you can see that this document was printed on the 3rd. So how can this certificate of service that is generated automatically by the e-filing system can be dated 12 days before the actual signing of the orders? This is illogical, right? So there's no one timestamp that is wrong. There's 3 timestamps, the one in the first page and the 2 certificate of services that he's attaching, right? And the other certificate of service that he's attaching is this one that says that it's supposedly a notice of entry of temporary orders from September 29th. Imagine that, right? So he's saying this certificate of service is saying that this notice was given to me on September 29th. So even before the draft that is contested. So the draft that is contested, and you can see that it's contested because Morgan Hybner, again, filed this exhibit list on the 15th with the things that she was going to use to make her point on the 16th hearing that never happened, right? And you can see in the things that she picked that she was going to discuss the validity of the drafts, right? And this was on the 15th, right? So how can she say that the notice of entry happened on the 29th, right? 14 days before, 16 days before, right? The day she was preparing to argue with exhibits to make her point that the orders should be signed, right? And it doesn't stop there. On the 16th, when we show up, because we show up for court, right? And I said, I filed this motion to recuse last night. Well, she said it, right? She said it on the record when they were calling the dockets, right? The first thing in the morning, she said, oh, this respondent filed another motion to recuse. We were here to get the order signed. And she said that, right? And there were like, I don't know, 25 attorneys that are all witnesses because this was on the docket call in the morning. All those attorneys that have a duty to uphold the law to the highest standards, all of them are witnesses that she said that we were there on the 16th to get the order signed. So she's saying that on verbally with 25 attorneys as witnesses, right? And me and everybody, right? It's on the record. Like this should be recorded, right? This courtroom has cameras and audio recording equipment. So she said that verbally, right? That we were there on the 16th to sign the orders, but now Pickett is saying that the orders were actually signed on the 15th, right? So all the evidence all the evidence that we're seeing, the 3 timestamps, the 2 from the certificates of service and the timestamp from the clerk, Morgan Hybner's comments in court in front of more than 25 witnesses, all attorneys, right? And probably on the record, saying that we were there to get the order signed on the 16th. All that contradicts what Pickett is saying, that the order was signed on the 15th. And then he attaches this document that says that was signed on the 15th, but it doesn't say at what time exactly. and it doesn't have the stamp on the top of the first page saying that this was filed on the 15th, right? So, I mean, what Pickett is asking us is to believe his word over the timestamps, 3 different timestamps, and Morgan Hybner's admissions on the record and in the court and in front of more than 25 witnesses that are registered with the bar that we were going to discuss the orders on the 16th. So, I mean, it's a hard sell, if you ask me. But it doesn't stop there, right? So as I was showing you, if you look at the judge entry, right, from supposedly the 15th, right, with the initials of Oscar Telfair and the supposed temporary order index 89 that they never served me with, like, I don't know what this contains, right? It could be a notice of hearing, like they have done this before, like I don't know what it has because they didn't serve me with it, and don't take my word for it. You can see the certificate of service that Pickett filed today, right, as proof that he had the order signed. The certificate of services don't match the 1015. They're dated weeks before the 15th of October, right? So this can't be the certificate of service. So this can possibly be the document, right? So this is a fabrication, a forgery, right? Now, but the nuclear evidence here is, I mean, all that is just peanuts, right? Compared to what I'm going to tell you now, which is the following. If you look at the temporary order, right, which says 1015, you see it got the index 89, right? But if you look down and you look at the respondent's second verified motion to recuse, it got index 88. So my motion to recuse got an index number lower than the supposed order, right? So that is proof that my motion to recuse took precedence, like it got into the system first, right? They may have pushed it down visually in this UI somehow, I don't know, right? How they internally manipulated it. But the index doesn't lie. They can change the index because, well, first of all, I have a system that takes hourly snapshots of this docket, like every hour. I have snapshots of this docket per hour, right? So if they mess it up, I will see the diff, and I will know that they committed fraud with the docket, right? So that's why they can change the indices, because then they would mess up all the indices from that point to the end of the docket, right? But the nuclear proof here is that my motion to recuse, my second verified motion to recuse, got the index 88. But the judge's supposed signed order got the index 89. So that means that it happened after, temporally speaking, in the time scale of things, right? And I can show you, because I have proof of this, right? You know, I'm the guy with the receipts, basically. I can show you where I show you this. Let me see. Okay. Okay, this is my motion to recuse filed and timestamp on the 15th and 8:14 p.m. Right, and you can see that it has the proper date, not like Pickett's document. Pickett's document say October 2nd, right? That is not the valid timestamp for what he's saying, right? My document does have the right timestamp, October 15th, and it's timestamped at 8:17 p.m. And this is crucial. See, I filed it after hour precisely because of this reason. And my document, as you can see in the docket, got the index 88. So that means, by logic, that if the judge entry got index 89, that means that he must have created that entry. The clerk, right? Whoever created this this index temporary order, this one that says temporary order, right? That got the index 89. That entry was really created after October 15 at 8:17 p.m. Sometime after that. It could have been on the 15th, but after that, or even on the 16th. I don't know. Right? I don't know. I don't have a magic ball. But what I can tell you is that it was probably created after my document because the index incremented. It's 89. It's not 88, right? And they couldn't take the index 88 because I had already took it, right? I had already taken it with my document. Which is the motion to recuse. And just by looking at the index, logic should, I mean, if a competent person analyzes this, it's logic it should be logical that my document should take precedence, right? Because I have the lower index. My motion to recuse should take precedence. So that temporary order, whatever is that they got really signed, that they never served to me. So it's invalid because they didn't serve it to me, but it's also invalid because it has an index superior to my motion to recuse. And after my motion to recuse is in the system, there is an automatic stay. So the judge cannot really sign anything. He doesn't have jurisdiction to sign that order, right? I mean, he could sign it, but it is not valid. He doesn't have the jurisdiction to sign it because he signed it after the motion to recuse was served and put in the system, right? And that is proven by the fact that I have the lower index in my motion to recuse, right? And I have the timestamp correct, right? October 15, 8:17 p.m. So, but it doesn't. The fraud doesn't stop there, right? So on the 16th, right? So we're talking about the next day after the motion to recuse, and 5 indices above, right? Right. So this must have happened. This is interesting. This is interesting. I have to debug this a bit more, but the other thing I was going to tell you is that so on the 16th, on index 91, there is a judgment notice sent to pro se litigants, meaning me, right? About the rule 30683 and 21F and 10. I looked this up in Google because I didn't have time to run a pipeline. I wanted to make this demo because this is time sensitive, right? Because the orders are set, the verbal orders, which is the only orders that are governing this at this point because nothing was signed. In reality, as you can see, because I have the index 88 with the motion to recuse, and there's no orders before index 88. There's no signature of orders before index 88, right? So anything that they put after index 88 in terms of orders is invalid. So, but you can see here, right, that the design of the rules of the fraud is really to get the court to sign something when at a point in time when it had already lost jurisdiction, right? They got desperate because they saw they would never get this order signed, and then they created this fraud, right? To create something in writing. But it's obviously fraudulent, right? But what I was going to say is that on the 16th, they sent this judgment notice, which is another violation of the process because remember, there is an automatic stay on the case. They cannot be sending notices of judgment because on index 88, there is a second motion to recuse. After index 88, there should not appear any orders or notices of orders or anything that has to do with orders, right? Because the court doesn't have jurisdiction. We all need to wait for the administrative judge to decide on the motion to recuse, right? That's what the rule says, right? So by sending that notice on the 16th, they are further violating my right to due process, right? Right. So index 90, 91, 89. Yes. Yeah, so you can see it clearly there, right? That they messed up somehow, right? They somehow were able to change the order visually in the summary, but they could not change the index, right? So the real limitation is, I mean, on their side, the technical limitation that they cannot overcome for some reason is the indices, right? Perhaps they know because they have me under such extreme surveillance that maybe they saw the requests but it's strange because I don't make those requests from my home. Like I don't know how they saw them. I have to think about how they could have seen them. I'm talking about the request for the snapshots that I take overly. Oh, I see. They saw it. I see where they saw them. They saw them probably in the logs of the server of this company that maintains the system for Bend County, right? They saw the requests coming in for this particular case, I see. Yeah, so that's probably why they didn't change the index, right? Because they knew that I would be able to prove easily that they changed the index, right? That they modified the docket, right? That they altered the docket. But it's interesting that The thing that gives it away is just a simple number, right? The 88, the index 88, right? The second verified motion to recuse that got an index that is lower than the supposed temporary orders, which have the index 89, right? So that on itself shows that I got there first, right? I was able to file the motion to recuse before they took action, and I think they took action because I filed that motion to recuse, right? If I had not filed it, and in fact, I have the petitioner recorded in a conversation with me the eve before that hearing, in which she told me, "Wait till tomorrow. You will see that I will get this order signed." She told me that on the 15th around 7 p.m. before she left Palisade Drive. So she told me the petitioner knew that the orders were not signed, right? And yet, Pickett is producing this document with her signature in the orders that are supposedly signed as form, as substance, and substance, right? So this is a complete fabrication, right? But the most telling thing is the index number, right? That is index 89, and I have the index 88. So this means that my motion to recuse got there first, right? So this, even if they had the timestamps correct, which they don't, right? The timestamps of this document don't match October 15, and they are dated weeks before. And this is a draft that was already objected. And she knows, and she's showing in her own exhibit list that is objected, right? Because she's admitting here on number 3 of her own exhibit list that there was correspondence on the 3rd about my objections, right? She's admitting to that. So she's admitting that this draft of October 2nd is contested. And crucially, you can see that it doesn't contain my signature. It doesn't contain my signature because I refused to sign it, because I objected it. I objected to it, right? You can see in the page of the signatures, right, that supposedly it was signed by everybody except by me. Now that I'm showing you this is a question that I haven't been able to figure out. I imagine it's a ruse of some kind, right? But I don't understand what it is. Look at how she wrote my name, right? Reynaldo J. Aguiar. But in the earlier documents on April, she wrote my name with the 2 last names, Aguiar Marcano. And you can see that when you look at the docket summary, you can see that it says Aguiar Marcano, right? So for some reason, at some point during the course of the litigation, she changed her MO in a way, right? And she started calling me Aguiar, but not Aguiar Marcano. These people don't do things randomly, right? Like if she's doing that, it's because there is a reason for that. But I haven't been able to figure out why. Like, what is the play with changing my last name in the middle of the thing, right? So anyhow, I'm mentioning this in case the Venezuelan informant, which I know he will see this in a few minutes, right? And I'm saying that not because he sees it on YouTube, but because I keep a second copy and I send him the audio, right? The audio only, via my secure communication channel. But the question for the informant is, what could be the play there? Why change my name? And in one of the hearings, when they were doing the docket call, in one of the hearings that were conducted via Zoom, I think it was the one on October the 3rd, 2025, when they were asking who was present, she misspelled my name. Well, I mean, not misspelled, but she used the only one last name. It's only Aguiar, right? So she omitted the Marcano that she had been using before. And she misspelled the case number, right? So maybe she has another client that is Aguiar, and she's going to make it could be, right, that she's going to make an excuse to say that she got confused with the other client, right? That the other client was the one that got signed. So maybe I should do that research, right? Maybe look for cases of another Aguiar, right? To see if any of them got order signed on that day, right? Because that could be a way out to explain the mistake, quote unquote, right? That she got confused with the other client. I don't know. I'm speculating, right? But I imagine there must be a reason for her to intentionally start calling me in a different way in the middle of the process, right? And this started more or less on October 1st, is when she started using one of my 2 last names, because I'm Hispanic I'm descendant of Hispanics, so we have 2 last names. So before October 1st, she was calling me Aguiar Marcano, my 2 last names. But around October 1st, she for some reason switched and started calling me Aguiar, right? there must be a reason for that. So, if the informant knows the reason, please, throw me a bone. But yeah, so the most interesting thing, right, besides the timestamps, which clearly show that the document is a fake, is a fraudulent document, really. The most interesting thing is the index number, right? That I got the 88 and they have the 89. So that tells that they're filing these supposed orders after, which also tells, because I filed mine, remember, at 8:17 p.m. So this tells you that they must have signed this document at 11 p.m. So the question, I think, needs to be asked: what special, how do I say this, considerations, right, this court has with the Adams law firm that makes this judge sign things at 11 p.m., right, or 9 p.m., 10 p.m., right, when the court is closed. It's super strange to me. And the other thing that is interesting is this. Look, let me show you this. Yeah, this is interesting. So look, there is 2 motions to recuse, right? You see, it's duplicated. The reason is because I filed it electronically at 8:17 p.m. And I also filed it in person in the morning around, and I have the printed copy, right? I can show you the copy. I'll put it in the folder. I filed it at 8:35 a.m. So right before the hearing of the 16th was supposed to start. The reason I did that is because mistrusting the system, because of all these abuses and frauds that I've seen, I wanted to make sure that I had, because the clerk cannot refuse a filing in person. They're obligated to take it, right? Unless there's something obviously wrong with it. So I went and filed in person to make sure that my motion to recuse got in, right? So that's why you see it duplicated. I have index 88, and the exact same document is also filed as index 93, which happened at 8:30 a.m. But this index is higher, right, than the index 88 that I got for the document during the night, and it's higher than the index 89 that they got for the document that is supposed to be the temporary orders. So that restricts the timeline, the possible times at which this order could have been signed, right? This order must have been signed between 8:17 p.m. on the 15th of October and 8:35 a.m. on the 19th, on the 16th of October, right? Because I filed the second copy of this document in person at 8:35 a.m. on the day of the hearing, on the 16th. So, and the index that they got, which is index 89, right? You can see that here, right? That index that they got is in between my 2 indices, right? So that's the thing that I wanted to show you, right? So that puts the signing of this order in between, so after 8:17 p.m. by pure logic, because they got one index above 88, and before 8:35 a.m. because they got an index lower than my second document. But in any case, it doesn't matter really when it got signed, because the important thing is that they got the index 89, which is superior to the index 88, which is the motion to recuse. So it doesn't matter really. I mean, it does matter because it could show the level of participation of the other officers of the court. Because how can they get this order signed after hours, right? When there is a hearing in the morning to talk about this draft without the other party present. I mean, there's so many violations to the process that my head spins, right? But so regardless where they got it signed, I mean, it's important because of, it shows more collaboration, right? If they can get orders signed at 2 a.m., I mean, you know, but in reality, for practical, application of the law, it doesn't matter because the index is 89, right? It doesn't matter where they got it signed after the index 88 got it, right? Which means that there's an automatic stay, and therefore that order holds no water. Like that doesn't have any weight. right? It doesn't have force. That order is invalid, right? It's not an enforceable order. It's not a valid order. It's a fraudulent order, right? Because it violates the automatic state that is in the Texas Code of Civil Procedure, right? And they can't change the code, right? So it's I feel like it's at this point it's like beating a dead horse, right? Yeah. But the other important thing, right? And this is it's like the cherry on top. If remember at the beginning, I told you that the appellate court, the first appellate court, dismissed my petition for writ of mandamus based on the fact that the orders were supposedly already signed. And you can see in the docket here in index 85, index 85. And these letters doesn't have an index, but I think these two documents were bundled together, right, as index 85. So this was this opinion from the appellate court saying, listen, your petition is a moot point because the orders are already signed. This was filed with this court on the 14th, right? Meaning that they made the appellate court believe that the courts were already signed before the 14th, right? By pure logic. And the reason why that court was deceived in that way is because Morgan Hybner filed this document mistitling it as notice of entry temporary orders, right? So the other court would see this and think, oh, the orders are already signed, right? But the cherry on top is in that they cannot have it both ways. Pickett is saying today in a filing that the orders were signed on the 15th. So he's admitting today, right? Today he filed a document admitting that they committed fraud against the first appellate court, because the first appellate court dismissed my petition for writ of mandamus on the 14th. So one day before Pickett is saying that the orders were signed. So either the first appellate court, which would be Judge Adams, he's the Chief Justice that signed that order, right, with two other judges, they either develop precognition, right, and on the 14th, they foresaw that these orders were going to be signed on the 15th, right? Somehow they knew that, right? Is the other explanation. Either that they developed precognition, or that Pickett is admitting that they committed fraud against the two courts, right? Because he's contradicting what the appellate court is saying. So how can we trust? Why should we trust what Pickett is saying over what the appellate court, which is a superior court to this court, is saying? The appellate court is saying that the orders were signed not on the 15th, on the 10th, right? That's what they're saying. But Pickett is saying that they were signed on the 15th, so they can have it both ways, right? They were either signed on the 10th, then therefore Pickett is lying on the filing today. Or if they were signed on the 15th, as Pickett is saying in writing, then it means that the document they filed on the 10th was a fraud upon the two courts, and they're admitting to it in writing today, right? So Pickett, I'm going to talk to Pickett now because Pickett, I think this is one of those cases. Tell you lose, heads I win, right? Like, but well, I think Pickett has the exit plan that he's going to say that this was given to him by Morgan Hybner, right? And if anything happened, it was Morgan Hybner, right? So that's why I think this is the scapegoat algorithm, and the scapegoat is going to be Morgan Hybner. Now, I have to also tell you, my Venezuelan informant told me, gave me information today. I don't know if this is true, right? It's unverified. And because it's unverified, I'm not going to say the name of the judge. But my Venezuelan informant told me today, and I'm going to timestamp it. So if this happens, if this is what ends up happening, it will just be confirmation of everything, right? The Venezuelan informant told me today, November 7th, 2025, and that was around 5:45 p.m. I'm not going to give the exact time because then they could, trace, right? Whatever they capture, right? But he told me that the network is planning to make a key judge in this process retire from the bench, right? And that would explain the delays, the confusion, it would explain the unexplainable otherwise, right? So if one of the, if this particular judge, and I put this in writing, I took a picture with a timestamp, a way that is timestampable to be able to prove that I knew this today, right? Before potential retirement is um, announced, right? So if a retirement of this key judge is announced, then it proves everything, right? But yeah, so I got that information, right? That a judge will retire, a key judge in all this. So let's see if that ends up happening. But yeah, so I think the two nuclear weapons in terms of ammunition for law enforcement are one that I got the index 88, and the temporary orders have the index 89, and Pickett is in writing making demands for money, right? Based on this fraud. This is wire fraud, right? I think. He's using an email system to commit this fraud, to demand money for using a document that it's clearly forged, right? Invalid. Yeah. And I say forged because the timestamps don't match the date that he's saying, right? And the signature block of the judge doesn't have the time in which it was supposedly signed, right? And the clerk's timestamp also doesn't match. And the service certificates, generated automatically by the e-filing system, don't match the date that he's saying where the order was signed, right? So he's making money demands based on a fraudulent document, and he's doing that over email. So that it's high liability, right? Legally speaking, criminal liability. And the second thing is the admission of him today saying in writing that the orders were signed in the 15th, contradicting what the appellate court, which is a higher court compared to this court, said on the 14th, when they said that the orders had already been signed, implying on the 10th of October. And that's the document that Morgan Hybner created fraudulently, naming it notice of entry, temporary orders, when in reality it was a notice of hearing for temporary orders, right? To deceive the appellate court. So she deceived two courts in one document, with one document. And Pickett is admitting to that today in writing, in a filing, saying that the orders were signed not on the 10th, but on the 15th, supposedly, right? Despite the evidence that Morgan Hybner served me with an exhibit list of the things that she was going to talk about on the 16th, a day after these orders were supposedly signed, according to Pickett, right? According to Pickett's filing of today, November 7th, right? So, I guess what I'm trying to say is that there is not even a single thing that you could think that would hint that Pickett is telling the truth, right, about these orders being signed. Like, there's nothing that you can hold on to, right? That's what I'm saying, that this is just too easy to see. And it could be a technique of creating a scapegoat, Morgan Hybner, right? So they're going to say that, well, she either was grossly incompetent, or in the worst case, right, that there's criminal charges, that she was a rogue lawyer acting alone for her own benefit, right? But this is in no way connected to Robert Mueller, right? Now, on the Robert Mueller thing, there's one thing that I want to tell you, right? I posted this, so this is a good, I'm going to give another session about countermeasures, right? On both sides. I'm going to talk about in that session about the countermeasures that the network is taking on the technical side of things, right? Not on the legal front. And the countermeasures that I've been taking, right? To kind of give you a view into the dynamics, right? But one thing I'm going to say is that one of the countermeasures I'm taking, so I'm not going to do that now, but I'm going to talk about this particular countermeasure, right? So I have a series of, and this is a bit technical, okay? I'm going to not make it too technical, but there's a series of Google Cloud Storage buckets that I use to store documents and things and videos and evidence, right? And I've noticed that they are capable of deleting things from the buckets. Like, when something is too damaging to them, they can delete them. Like, I've seen things that I caught things that they've deleted, right? I'm not going to tell them here what I saw, right? But I have multiple instances that I've seen that they have deleted them. So of course, the question in my mind has to be whether there's complicity from within Google in deleting these things, or is that they got a hold on my credentials somehow and got into my account and deleted them, right? So for this reason, my confirmation, I created a bucket that has a retention period, mandatory retention period of years for all objects. This is a way that you can set up the buckets for compliance reasons. For example, if you're a bank, if you're a law firm, right? Like you want the things to be unchangeable, so nobody can do what Morgan Hybner does, right? Of this thing of changing the documents and changing the what happened first, right? So you want the objects to be immutable. And this bucket, I have it configured in a way that it cannot be deleted. No object can be deleted. I'm going to delete one object so you can see that it fails. It's going to take like a few seconds to fail, right? But so it's saying, trying to delete this image that I put in there, and it's going to fail because I set up the bucket in a way that no object can be deleted in years. So this is an immutable bucket, basically. Once I create an object, I put something in, it cannot be taken out. I'm saying all this because if they happen to delete things from this bucket, then it proves that there's collaboration from Google, because even me, I can't delete things, right? I just showed you, right? Like you can see that it says the image cannot be deleted, right? So even with my own credentials, and I'm the owner of the bucket, I cannot delete things, right? So if they delete things from here, it means that, somebody from Google internally is helping them. So in this bucket, right, I created a folder called evidence, and I have like only the most important things, right? So in this, there's a folder for Robert Mueller and Joel Grade, in which I put a video of the day after I created. So this video was recorded the day after I created the demo, recorded the demo, and posted it on YouTube, talking about the hypothesis that Robert Mueller's modem could be buried under that concrete lid on his backyard, right? And there's a full demo about this. So the next day, this video was recorded by the security cameras, right? You have to download it to really view it. But I also posted it on YouTube, right? And this is important because it shows what I think was the removal of the modem that they had at the Cuban safe house. So it's this one over here, right? What I think was the removal of that modem, right? And at the end, you can actually see the object that they took out from the ground, right? And remember, this was one day after I posted that video on YouTube about Robert Mueller potentially having that modem in his backyard buried under concrete, right? And then the next day, on the Valley side home, the other home, this crew comes, digs into the concrete of the curb, and takes out equipment, right? I think they took out the modem, is what I'm trying to say. And I'm saying this in the context of this conversation because I remember when this modem was, I'm calling it a modem, okay? When this equipment, right, was installed. Let me reduce this size a little bit. Okay. This was installed, and I have some photos and everything. This was installed when my son was just a few months old. Right? A crew came and dug in that exact place, and I didn't see what they did, but I saw them digging, and I took pictures of them. Right? And this is important, right? Because and this is a plea to authorities that I'm making, right? If you investigate this thing and you determine that thing that they removed from there, from Lara Creek Drive. So this is the house that is next to my home in Valley Side, less than 100 feet away, right? So let me show you where this was, right? So 26 Valley Side Drive, okay, right? Right. So this is my home at Valley Side Drive, right? That equipment was removed exactly from this point. Like you can see how close this is, right? And this was the next day after I posted that demo on YouTube. So my plea to authorities is that if you investigate this thing and you realize that that was a modem that they took out, a power line communication modem, similar to the one that Robert Mueller has, that would mean that he had a direct point-to-point communication from his house to this house that is feet away from where this child that is today kidnapped using the courts and legal means, but he's kidnapped, right? Was born. Right? So that means that he was targeting. I'm talking about Robert Mueller, right? If this is proven, it would mean that Robert Mueller was targeting that child since he was born, right? Imagine the implications of that. I don't know how old Robert Mueller is. I'm gonna look it up. So he's 81 years old, right? This must have been, I don't know, 3 or 4 years ago, right? 3 years, say 3 years ago, he must have been like 78. So what I'm saying is, if this is proven, it would mean a 78 years old man targeting a child that is a newborn, right? And him with the aggravated factor of him being a former FBI director. I mean, I've said this multiple times. Like, I'm not a person looking for revenge, or I don't believe in that, right? But I have to say, like, if this is the case, right? If an 80 years old man is targeting a newborn in this way, I hope that the FBI makes an example out of him, precisely because he was the director of the FBI, right? And I'm mentioning this in this context because this thing that Pickett is admitting in writing today, that they committed fraud against the court to keep the child kidnapped, right? And what he's doing by fraudulently creating this document that extends the duration of the orders indefinitely, right? Contradicting what the judge verbally said on September 11, what that causes, like the effect of that, is to keep the child kidnapped. So what Piquet is doing with that action is prolonging the kidnapping, right? So I plead to authorities, you have to put a stop to this. Like, there has to be an end to this. Piquet cannot keep that child kidnapped forever. Please. Pickett, Robert Mueller, and Joel Gray, right? Because all this was triggered when that black Tesla was transmitting infrared signals to Joel Gray's house, right? And Robert Mueller installed that modem to have point-to-point communication with the Cubans in Lara Creek Drive when the child was just weeks old, right? Or a few months old. So it's, I think the severity, right, the gravity of the situation calls for intervention. Well, I think this is a good point to stop this session. And I'll make another session soon about the countermeasures. It's going to be a very interesting technical session aimed at technical audiences and people working in counterintelligence. So I thank you for your time and for your help, and I'll see you on the next one. Bye.